their lordships have created in this decision of Bankumzandira is if the results that have not come are officially cancelled. That was not the case. No, they were not. They were not cancelled. The returning officer simply proceeded, declared the winner without receiving all results from the constituency, my lord, as is the command section. Let me begin with the law, my lord. Section 72, the PEA, which the lordships in Muzanira were interpreting. You are interpreting the former section 58. Now it is 72. 1. Now it is 72.1. It provides, my lord, that 72.1 says after all the envelopes containing the declaration of results forms have been received, the returning officer shall, in the presence of the candidates for their agents, or such of them as wish to present, open the envelopes and add the number of votes cast for each candidate. You do not declare a winning candidate without all the envelopes. Now, my lord, in Bamzania, they said, of course, you can begin tally, okay, if there is, and that's also what they for in there. You can begin tally, but declaration, you do not do so until you have received all envelopes. I was saying that the exception, my lord, they created is of the decision, my lord. I'm at page 751 now. 751. I'll get for you the page of the exception, my lord. If they're not complete, my lord, that's all. If a constituency has 197 polling stations and you have results of 170 polling stations, they are provisional. Even that, my lord. Even that, my lord. Even that, my lord, which you have said, happened and is unlawful. First of all, what you have just said happened in this case and is unlawful. Okay? At the time of declaration, the results were different. At the time of gazette, the results were different. In Muzanira, the Court of Appeal has said that is unlawful for the returning officer to first and foremost. This decision has told you once you issue a return form for transmission of results, you can't touch it. So, my lord, I only put the final declaration where that which you were saying. No, my lord. The previous results are, but that was not my point. The point was that because you do not have all 197 envelopes, DR forms. The only implication is that what you have declared are provisional results. I was, my lord, taking you to the exception that you had asked me. That same page, 751. Yeah. Just below the second highlighted part, there, my lord, you are saying, unless they are cancelled. And the second respondent did not tell us that they cancelled. They did not. And the cancelling, my lord, is not by invitation. We appreciate, my lord, after the second highlighted part, down there, after the second highlighted part. Down there it says, we appreciate that there are cases where certain results may be missing or cancelled. And the available results are used to declare a winner. None of those applies to this case. They were not cancelled, they were not missing. So that's the compliance by law. So the law commands the returning officer to only they were not missing. No, my lord, you cannot miss something that doesn't exist. It was a question of non-existence of that, not missing results. Missing results is this: that results have been declared, like in Yakechu, Saropen. Results have been declared, the other forms have been filled along the way, the transmission. Then they disappear. The court of appeal has dealt with missing results. These were not missing because they were not there in the first place. So I'm saying this therefore does not apply to our case. And cancellation, my lord, is of course you can't do it by word of mouth. Okay, there is a procedure, my lord, if you want to cancel results. And the EC has not said, my lord, that they cancel. Not at all. What? Then the question, my lord, will be, what does the law tell them to do? I've just referred you to the law. Postpone. Yes. The voting. Get to the next. And how? Because you see, my lord, after the election is held, the law commands the EC to declare a result in 48 hours. They still had time. Yes. So they could have held the election again in those 14 polling stations. The next day, they don't give them that option. And they did take it. The first respondent and the petitioner is 8,881 votes. Those whose choice we do not know, but we are clear voted at the election, is 16,640 votes. They are almost double the margin. They are almost double the margin. 16,640. 640. But the margin. Yes, I think you question, my lord. Yes. 14 points. Yes, ma'am. The tally sheet. So subtracting this from the. Yes, my lord. Yes, my lord. Okay, they'll do that, my lord. As required. But you can also get it. Okay, my lord. But you can also get it, my lord, from the tally sheet. The tally sheet gives you the number of registered voters per polling station and also voting. If you look at the tally, it would be easy, my lord, but even that they can do from here. But you can disengage from the tally sheet. I'm obliged. And what I was saying, my lord, is that the margin between the winner and the first runner-up with the petitioner is half of that number, nearly half of that number, at 8,881 votes. When she was here in cross-examination, probably also say this, my lord, when she was here for cross-examination, Mr. found it quite a bit. The petitioner stated that in those 14 polling stations, apart from the fact that that's where she votes from, in one of them, but those were also her strong votes. And that evidence was not challenged, my lord. My lord, why I mentioned that point is because the case overturned Kookie Moses versus arranged at the Court of Appeal, my lord, the case and order. At page 900 of our plan of commodities. But that's now going 3, my lord. Atan Okia Moses versus Abib. 9:54, yes, it begins at 9:33, but the holding is at 9:54. In fact, my lord, when she was here, Mr. Baba said, hey, those were strongholds, okay, have the votes. Have them. She actually gave them the vote. So the fact that they were not, they were strongholds was not evidence. Now, my lord, let me also give this test. Because it might be confused. How do we get substantial effect? Because I saw the first respondent trying to bring another formula.